everybody to the Fort Bend County Parent Support Group, and we are pleased here to have KirkMonroe with BrazosBendGuardianship. So Kirk is a native Houstonian, and he's been in social work for 31 years. He first began working with individuals with IDD in fall of 2003 at Texana, and he was a consumer training specialist. The Fort Bend County hired Kirk in the fall of 2004 in order to develop a local guardianship program, which became known as the Guardianship Assistance and Alternatives Program, or GAP. This program evolved into BrazosBendGuardianship Services, which Kirk has been the executive director for since September of 2008. So celebrating 10 years. Yes. Congratulations. That's a milestone. It's a huge milestone.
Yes, it is. It's hard to believe it's already been 10 years, but
it's flown, right?
Yes, it has.
So, but Kirk has been a Texas certified guardian since 2007, and BrazosBendGuardianship Services currently serves as the court-appointed legal guardian for 59 adults, primarily in Fort Bend County, and the majority of those people do have an intellectual or developmental disability. So, without further ado, please help me welcome KirkMonroe.
Thank you, Gary. All right. Well, thank y'all for letting me come out and just visit with you some today about guardianship. And so let me just get a feel here. So what are the ages of your children?
11.
11?
Mine is 4 and a half and 3.
Okay. Okay.
15.
15? Okay.
10.
10. Okay. All right. Well, the good news is you've got plenty of time here. But yeah, I do want to, like I said, I really do want to thank the ARC. The ARC, they were the ones who actually decided back in '04 to apply for a grant. It was a state grant at that time that was encouraging the development of local guardianship programs. And Cynthia Keene was the executive director at that time, and they applied for that grant and received it. And when I first came on, Charlie Huber was he was on the ARC board, and I credit Charlie for helping me learn what I know about guardianship. And so I appreciate him. And then also, Charlie's wife is Amy, and Amy is you're LCSW, right? And she is also on our board. She actually is, she's our incoming president starting in January. And she also serves on our ethics committee. And our role as guardian, we are often faced with having to make some difficult medical decisions for our clients. And so we, instead of carrying that burden alone, we have an ethics committee, and so we have Amy, and then we have Dr. Jerry Vogue, who's a dentist that serves on that committee, and they come and hear the information and then help us come to a decision about what needs to be made for our clients. So, but today we're going to focus on guardianship. Our information sessions, this was one of the first things we started doing. I've been doing information sessions out in the community since December of 2005. And we still do the information sessions on a very regular basis. You're always very welcome to attend one of those. And we usually do them at one of the local libraries, either George Memorial Library or the University Branch Library. And right now, another one of our board members, Eric Junker, who is also an attorney, he co-facilitates that session with me. And he does a great job, especially when it comes to talking about trust and alternatives to guardianship too. So, but we're going to focus today on guardianship, and I always make a disclaimer up front, and that is that the information you're about to receive is information. It cannot be seen as legal advice. We're fortunate to have Charlie here in the room with us, so that way if you do have a legal question, we'll be able to get him to help answer that question for us. So, and please, this is very informal. You feel free to raise your hand as we're going. If you have a question about something or you need to clarify something, please let me know. All right, and so our goals for today, we want to inform you about guardianship, why guardianship might be necessary, what are the steps involved in obtaining guardianship, and then what your responsibilities are going to be as a guardian. And then, like I said, we also just want to make sure you have an opportunity to ask questions as we're going throughout the session. Okay, so why do I need to consider guardianship or an alternative to guardianship? Well, know that when anybody turns 18, they become their own legal guardian regardless of their level of functioning. And so when we're thinking about guardianship, right now, you're the guardian of your children simply because they're minors. They're under 18. It has really nothing to do with the fact that they have an IDD. It's because you're their biological parent. And, so when they turn 18, though, by law, to become their legal guardian, and in order for a parent to continue to serve in the role as a guardian for their own child, they have to go through the legal court process, and the individual has to be declared incapacitated. So guardianship of someone 18 and older is very different than that of someone under 18. Know that the parental rights that you have under the Individuals for Disabilities with Education Act, those are going to transfer to your child when they turn 18. So probably when your child is their 17th year, you'll start hearing in your ARD meetings, the school has to by law inform you that once they turn 18, they will be looking to the child to make their educational decisions. Okay. Know that healthcare providers must comply with the HIPAA laws, and know that medical facilities and doctors may not perform non-emergency procedures with someone who's unable to give consent. So this is probably one of the other big reasons that parents oftentimes are seeking guardianship of their child after they turn, or once they turn 18, is if they develop a certain medical condition that may require treatment, if a doctor feels that they're not going to understand the treatment that's happening to them, then they may not perform that procedure. Now, let me stress here, this is a non-emergencies procedures, okay? There are provisions in the Health and Safety Code that allow next of kin to make decisions in emergency situations. And then it is wise just to have a plan in place so that an incapacitated person or someone that becomes incapacitated will be properly cared for, and to reduce the risk of the incapacitated person from being neglected and or exploited. And know that the judges, the courts, they're required to make sure that all viable alternatives to guardianship have been considered before granting a guardianship. And like I said, I'm not going to get into a lot of alternatives to guardianship today, but when we talk about alternatives, we're referring to like a medical power of attorney, a durable power of attorney, talking about supported decision making, and actually the guardianship application now has to address that all alternatives have been considered and found not to work for the individual. And of course, because guardianship does remove rights from an individual, we do always support using the least restrictive alternative available. Okay, so this is the question I'm often asked too as well. So how do I know whether I choose guardianship or alternative to guardianship? And I can't tell you that there's a magic answer to that question. But what I can tell you is that you want to consider the level of capacity of the individual. What is their ability to make an informed decision? We all make informed decisions just about every day. And usually when we're making an informed decision, that means we're gathering the facts. Sometimes we get second opinions. Sometimes we get on the internet and that scares us with the information we read on there. But we do gather as much information as we can so that we can make an informed decision. And so think about your loved one, you know, and what, you know, if they're presented, and I still use the example here, if they're presented with a certain medical condition that they're going to have to choose treatment A, B, or C, you know, what is their ability to be able to understand that information, even with guidance from you, and still make a decision about what treatment to choose, okay? Also, you know, when families are on the fence about whether or not to pursue guardianship, always encourage you to talk with the loved one's doctor, especially one that has a long history with them. And here in a minute, as we start talking about the process, you're going to have to get a doctor to complete what's called a doctor's letter anyway. And so, so sometimes when, like I said, families are on the fence, it's good to talk with the doctor to kind of get their opinion about whether they feel, you know, guardianship would be beneficial or not. And this came from the ARC of actually Greater Houston's guardianship manual many years ago, but I love what it says. It says that guardianship is only an avenue to pursue if the person's parents, doctors, psychologists, and caregivers, such as teachers, all agree that the individual is incapable of making informed decisions with appropriate guidance and information.
No, that was me. Go ahead. Sorry.
It's like I was buzzing. Okay, so we're going to dive into guardianship now. And before we get too deep into it, just want to define some key terms. You've already heard me refer to the word incapacitated. And let me also say that, you know, guardianship is state law. So we look to the Texas Estates Code to get the information we need. And that's where attorneys look, judges look, to get the information that they need to, you know, hear a guardianship case. And so the definition of an incapacitated person in Texas is an adult who, because of physical or mental condition, is substantially unable to feed, clothe, or shelter himself or herself, to care for their physical health, or to manage their financial affairs. And so what's important to understand about this definition is that as a judge is hearing a guardianship case, this is what they're going to be listening for. You know, does the proposed rule meet this definition of being an incapacitated person? Now, you've heard me refer to the word ward, and that is an incapacitated person who's been placed in the care, custody, and supervision of a guardian. I will tell you, over the last couple of legislative sessions, they've worked on maybe trying to change the word ward, because ward is kind of such a cold and sterile term. I know the last session they looked at, I think, person with a guardian maybe. And I think that that's going to come up again, possibly in this next legislative session. But right now, this is what is in the Texas Estates Code. And then, of course, a guardian is a person or entity to whom the rights have been delegated on behalf of the ward. So, as a parent, as you go through this process, you appoint a guardian, then you become the one who, you know, those rights have been delegated to you.
So
Okay.
it'd be ward of the guardian, ward of the, it would be ward of the state, ward of the guardian, ward of the what?
Ward. Well, you talk about the word ward?
Yeah, when you use it, it would be, so this person becomes ward of the guardianship, ward of the court, ward of the state, how does that?
Those are good questions. Because, you know, once a court actually establishes a guardianship, they have a responsibility to continue overseeing the guardianship. So even a guardian still has got to answer to the court that's overseeing that guardian. Now, but know that you as the parent, if you become the legal guardian for your child, then, I mean, they become, basically, they continue to be your responsibility, so to speak. You may have heard the term guardian or ward of the state. Know that through the Texas Health and Human Services Commission, there is an Office of Guardianship. And the state actually can be appointed as the legal guardian. But they're often only appointed in situations where like maybe a child is in part of the CPS system and parental rights have been terminated. And so sometimes the state has to become guardian for them, especially if they turn 18 and they function at a level they still need a guardian. Or if Adult Protective Services goes out and does an investigation on an individual.
So when a child, I guess when a child is like 17, is this when you start looking at whether or not you think that the child needs a guardian or they can handle their financial affairs or?
Right. Okay, yeah, she was asking, so at what age, like 17? The earliest that an application can be filed with the court is when the child is 17 and a half.
Okay.
And the courts will probably not hear the case until they turn 18. And are all of you in Fort Bend County? Okay. It is actually, we have, starting January 1, we're going to have 6 county court of law judges. And it is one of those courts that will hear the guardianship case. We've had 5, we're adding the 6th one starting January 1, and I will say 4 of those 6 judges are new on the bench. So, now one of them, she did serve a year, Judge Wallace served a year before. Okay.
I have a question.
Yeah.
So if you get a guardianship from Texas and for any reason you move out of state, so does it affect the guardianship?
Okay. She's asking if you get the guardianship established in Texas, if you move out of state, does it affect it? The answer is yes. Do you want to answer that, Charlie?
It could affect it depending upon the law of the state where you are moving to. There is a typical procedure in the new state you would move to that would allow the guardianship established in Texas to be transferred to the new state. But the laws in all of the states vary a little bit.
Right.
So if you were to take yourself and the ward to the new state and establish residence there, you would then want to talk to a lawyer there about what the procedures require so you can set up the guardianship under the court in the new state and end the guardianship in the court in the old state.
Okay, yeah, okay. So if we ever to move, we have to keep that in mind.
Correct. Now, if you move within the state of Texas and move from one county to another county, it will then transfer to the county, to the court in that county that has.
So we still have to inform in that case as well?
Well, correct. And usually what happens is, and we'll get into this here in a little bit, but one of your duties as a guardian is you have to file an annual report with the court. And you have to put on there the address. And so usually the annual report is what triggers the court being made aware that maybe you've moved to another county.
Oh, okay.
And so let's say, for example, the guardianship was established here in Fort Bend County, and you move into Harris County, then they would work at transferring the case over to Harris County. Now, I know that guardianship is always based on where the ward or proposed ward is residing, not the guardian.
Right.
Okay. So if you stay here in Fort Bend County, but the ward winds up like in a personal care home or group home in Harris County, then the case would transfer to Harris County.
And what about if traveling? Because I was like in some cases you have to have different insurance. If you're traveling out of state, so does it affect traveling as well? What if I'm traveling out of state for a month and she gets sick over there?
Right.
So, and I need like a signature for something for her, so what does my guardianship play a role in that position?
Sure. Well, you will, once you're appointed as the guardian, you're gonna carry with you what's called a letter of guardianship.
Right.
So that's going to be your legal document to show that you have been appointed as the guardian. And usually when you're only traveling temporarily, it's usually accepted,
Okay.
like by a hospital or a doctor, to know that you have the authority to make those decisions.
Okay.
Yeah.
Okay.
Good questions.
Thank you.
All right, so let's talk a little bit about the purpose of guardianship. And I've already touched on it a little bit, but we'll dive into a little bit more. And we'll look to Texas Estates Code 1001 to find this out. And it says that a court may appoint a guardian with full authority over an incapacitated person, or may grant a guardian limited authority over an incapacitated person, as indicated by the limitations, as indicated by the incapacitated person's actual mental or physical limitations, and only as is necessary to promote and protect the well-being of the person. So those are some key things here from this definition alone we can pick up on. And one is that the purpose of guardianship is solely to help protect the individual. It's not necessarily to control them, but it's to help protect them. And then also, we can pick up here is that a court may grant full authority or limited authority. And so what that means is that if there are certain areas within your loved one's life that they are able to make decisions for themselves, and the doctor's letter is in agreement with this, then by law they're supposed to retain that right to be able to make that decision. And so if they even retain just one right, that is then what we call a limited guardianship. Okay, and so what's nice to know about this is that, you know, sometimes individuals do maybe function at a level that they can handle certain areas by themselves well, but maybe they just cannot make financial decisions, or they just cannot make medical decisions. Then the guardianship can be set up to where you as the guardian would have the power to maybe make the decisions in those areas that they are not able to, but they still retain the rights in the others. And once again, the doctor's letter has to be in agreement with that, and we'll go through that here in a minute. So, guardianship is a legal process designed to protect vulnerable persons from abuse, neglect, including self-neglect, and exploitation. Guardianship provides for the person's care and to the largest extent possible that person's independence and right to make decisions affecting his or her life. All right. Okay. Also think it's important to understand that here in Texas, we have what's called guardianship of the person and guardianship of the estate. Guardian of the person is someone who's appointed by the court to take care of the physical well-being of the ward. So this means that as a guardian of the person, you're able to make medical decisions, you're able to make placement decisions, like decide where they're going to live, you're able to make educational decisions. Guardian of the estate is appointed to care for a ward's property, that's real and or personal property. And now know that a guardian of the estate is typically not needed to manage a federal benefit like supplemental security income or another form of Social Security. And usually you're able to be appointed as the rep payee by Social Security to do that. And the reason I want you to understand these differences is in most situations of when it's a family and it's an IDD, a child you're looking to become a guardian for, all you really need to obtain is guardian of the person, okay? And so as you call and talk to an attorney to find out about maybe the cost to obtain a guardianship, if you can be more specific with them and say, hey, I'm looking to obtain guardianship of the person, non-contested case, my child with an IDD, that helps them know, and then they can better tell you maybe a quote. Because there's a big difference in price. You know, your guardianship of the person, non-contested case, you're looking at maybe $2,500 to $3,000, whereas guardianship of the person and estate is about $3,000 to $5,000. And so sometimes when you call an attorney and just say, hey, how much would you charge to do a guardianship? They're gonna, without knowing all the other details, they're gonna have to assume it's a guardianship of the person and estate a lot of times, and they'll tell you, you know, the price for that. Now know that, you know, the attorney will still meet with you. They're gonna ask you enough questions to make sure
Right.
that they know the type of guardianship that has to be established, okay? Now, like I said, guardian of person in the state, like that's rarely needed. And I'm gonna kind of remind families though here, the reason that I sometimes talk about this too is, the process to obtain guardianship right now is the same, whether it's a parent seeking guardianship of a child with IDD, or if it's you maybe seeking to become guardian of your elderly parent that's now in their 80s, they've come down with Alzheimer's, and they need a guardian. Okay, so the process is the same. Okay, and now, a single guardian versus co-guardianship, and by this what I'm meaning is, can more than one person be appointed at the same time to be guardian? So, can two people be appointed as guardian of the person of my son or daughter? And the answer to that question is yes, but know that it's a husband and wife only. Okay, it cannot be like mom and an adult sibling. Okay, it has to be only a husband and wife. Now, you know, the biological parents, of course, can be appointed. If they're divorced, it just needs to be an amicable situation for the court to be able to make that happen as well. So, all right.
One more question.
Yeah.
So is there any way like primary and secondary guardians? Like if me and my husband are guardian of my daughter, and if something happens to both of us at the same time, so can we appoint somebody ahead of time?
That's a great question. And it often comes up.
Oh.
Okay, and so, you know, usually what families are encouraged to do is to put in their will who they would like to become the successor guardian of their, you know, of the child that they're guardian for. Now, know that's not an automatic appointment though upon your death.
Right.
They still have to make application to the court to be appointed as the successor guardian, and the court has to make sure that they qualify to be the guardian.
So what about the time meanwhile? Like,
well, I mean, there could be a little bit of a time lapse there, but usually if the successor guardian, with the help of the attorney when they're filing their application, if they inform the court, look, you know, both parents have, you know, they suddenly passed away, we need to get a successor guardian appointed as quickly as possible, and then they'll take as quick of action as they can.
can that be more than one person?
Is a successor guardian?
Yes.
Charlie, you want to answer that?
Yeah.
If it can still be a husband and wife?
Yes, there's no reason that two people could not serve as successor guardians. But what the court would be looking for is a situation where those two people are like a husband and wife. And if one of those two people is not a biological relation to the ward, the preference of the court would be not to have that person, probably. I got a couple judges over the years to agree to allow a non-biological new spouse of the parent to serve as successor guardians.
So I was.
But the judge said, well, I'll do it, but maybe we shouldn't be doing it, but I'll do it. So that's the answer.
So in my case, I was wondering to put my elder daughter and my brother. So can they both?
Oh, no, well, the answer to that would be no. The judge is gonna want one of those two people to be the successor. But since your other daughter and your brother aren't married, the judge is gonna say they can't be
Even though they are
co-guardians.
biologically related
Right.
to my,
That's right,
to the ward?
that's right. You'll have to choose one of them to be the guardian.
Oh, okay. And if my daughter becomes the successor, can she further put down my brother as a successor?
She
in
could
her
say that
case
if
of-
something happens to her to make her incapacitated, and unable to serve, then she could say her preference is that your brother
Okay.
would then go
So
qualify.
that, okay, I just wanted to make
Yeah.
sure. You never know.
No,
what
those
could
are great
happen.
questions, and those are
No.
very, those are very common questions we get about the successor
Okay.
guardians, so, no, that's why we're here. And know that the estates code, it does dictate prioritize persons who are eligible to become guardians, and the court will also consider what's in the ward's best interest. So, as I mentioned, this process is the same, whether it's, your child ID or someone with Alzheimer's, or some other type of dementia. So that's why it says spouse on here. And then, of course, next to kin. Now, if there's no family member willing or able to serve in that role, then the court will look at an agency like ours to possibly become the guardian or successor guardian. And we've become successor guardian in several situations because of something happening to a family member and there was no one else there. That's part of the reason we exist here. We want to be there in those situations when there is no one else that can serve in that role for them. So, when you see bank and financial institution up there, those are going to be more just guardian of the state type situations. So, okay. So Charlie mentioned it. I mentioned it. But the court has to make sure you qualify as a guardian. And so, what does that mean? Well, it's easier to talk about who's disqualified. Anyone under 18 cannot be a guardian. A person whose conduct is notoriously bad, that's what it says. But know that now even family guardians have to go through criminal history checks, and we'll talk about that too in a little bit. A person who is a party or whose parent is a party to a lawsuit concerning or affecting the welfare of the proposed ward. A person indebted to the ward unless the debt has been repaid prior to appointment. A person asserting a claim adverse to the proposed ward or the ward's property. A person who by lack of education or experience is incapable of prudently managing the ward's estate, or a person, corporation, or institution found unsuitable by the court. Now, it's also presumed not to be in the best interest of a ward to appoint a person as guardian if they've ever been convicted of any sexual offense, a sexual assault, aggravated sexual assault, injury to a child, abandoning or endangering a child, or incest. All right. I gave everybody, actually, I made a copy of this for you. This is kind of a flow chart, so to speak, of the steps that are involved in obtaining guardianship. You'll see it there, meet with an attorney. I'm often asked this question too, do I have to use an attorney? And the answer to that question is yes. The courts do require that you use an attorney to represent you. And that is because in guardianship, you're actually asking the court to remove the rights of another individual, not yourself. So, because usually when you're in pro se situations, it's really just concerning you. But in this situation, you're really affecting the life of another individual. Now, what type of an attorney? Of course, any attorney that does probate, and more specifically does guardianships, are the type of attorney you would want to seek out. And I also add to that you work with an attorney that's familiar with the Fort Wayne County court system as well. We always, we keep a list of attorneys on our website. We have a resources page on our website. Hopefully everybody got one of my cards, and our website is on there. There's a wonderful resources page on there. And we have a list of attorneys. The forms that you have, the doctor's letter, the annual report, they're all on that resources page. And there's also information on there about spur decision making as well. Now the book that I give out at our sessions is also on there. It kills a lot of trees because it's about 56 pages, I believe. But that book is on there, and it's also available in Spanish too. Okay, so once you meet with an attorney, like I said, they're going to sit down with you and they're going to ask a lot of questions, because what they're going to be having to do is work on an application. And so we refer to this attorney actually as the applicant attorney, because you're making application to the court, asking the court to appoint you to become the guardian of your son or daughter. Now, another document that you're going to have to provide is what's called the doctor's letter. And you should have a copy of that in front of you, and I'm going to scroll down to it just so I can show you, hopefully, how well it looks. Okay. It's also called Physician Certificate of Medical Examination. Now, I know it's going to be a few years, a couple of years over here before you're ready to apply for guardianship, but always make sure that you have the current doctor's letter, because these are put out by the court. And see, this one was revised in like October 16, and it's still the current one they're using. But they do update them every so often. And so usually to the Fort Bend County Clerk's office, they usually also keep the current forms on their website as well. So, but some key things to understand about this doctor's letter is that, one, it has to be completed by a licensed doctor. We're starting to see a lot more like nurse practitioners and some other professionals that are helping the doctors, but they cannot sign these doctor's letters. The court will reject it. So make sure it is a licensed medical doctor that completes this letter for you. Now, you can also use the psychologist that performs what we call the Determination of Intellectual Disability Assessments. And then those are usually the psychologists that work for Texana, which there's 2 of them. And this is an assessment that your child will have to go through, because this is the assessment the state requires before they can start offering services to someone. Okay.
Question.
Yeah.
Can a psychiatrist fill this out, or does it have to be like a pediatrician, for example, or what kind of doctor does it have to be?
Well, just as long as it's a licensed medical doctor. And I will tell you, the doctors that are going to be most comfortable filling it out are going to be the ones that have a history with your child.
Okay.
Okay. Now, the psychologist at Texana may not have much of a history, but this is what they do on a regular basis. I mean,
So
they do
they
these.
can also do that?
They can do the.
So their signature will be accepted?
From the psychologist at
Yeah.
yes, because I believe they're both doctors anyway. There's Dr.
Right.
Brent Worthen, and then there's another lady there.
I can't think of
Yeah.
her name right now. There's a lady that
Yeah.
can't think of her name.
And then, now I will tell you though, Texana is now charging for families to do the doctor's letters.
Okay.
And it can take, you may be looking at 4 to 6 months as well if you were to call them up. So just keep that in mind as you start this process. But I will tell you, there's one advantage of getting the doctor's letter completed by Dr. Worthen or with the psychologist versus the medical doctor, and that's the time frame that or length of time that the doctor's letter is good for. You'll see up there that it says that I last examined the proposed ward on, and of course the doctor has to put a date in there. If it's a pediatrician or other doctor, know that the application for guardianship has to be filed within 120 days of the date that assessment was completed for it to still be a valid letter. Doesn't mean the hearing has to happen, it just has to be filed with the
within
court.
that time period.
Pardon?
It has to be filed within that time
It
period.
has to be filed with the court, right. Now, if you use the psychologist that do the DID assessments, as long as the hearing occurs within 24 months of the date they did the assessment, it's still considered a valid letter.
Oh,
Okay, so it's, as I'm saying, that's your advantage, is you have a little bit longer time.
okay.
Okay, if you
And since their if they take longer to give you the appointment, it's better to have this be done and then start the process.
Well, yeah, I mean, like I said, the earliest you can file the application with the court is when they're 17 and a half.
Yeah.
Right. So, yeah, so just keep that in mind. And you'll see too that the doctor has to check on there that before the examination, I informed the proposed ward that the communication with me would not be privileged. So that's meaning that they're not keeping this confidential. They're going to be sharing it. And so they have to inform them of that. So the a critical part of the doctor's letter is this question number 5, where ability to make responsible decisions. And this is where the doctor's got to go through and indicate what they feel your loved one is capable or not capable of doing. And so you'll see questions on there like, can they make financial decisions? Can they manage a personal bank account? Safely operate a motor vehicle? Vote in a public election? Make decisions regarding marriage? So these are some real critical areas here. And so they have to indicate whether they can do it or cannot do it. And then if it's a determination of intellectual disability, there's a box there where the doctor goes in and checks. Now, I believe this is restricted, right, Charlie? That this has to be completed by the psychologist?
Yes.
Okay. So like Dr. Worthen at Texana, I believe he would only be able to fill like this.
Okay, so even
box
if you
out.
get the whole application done by a physician, this part has to be done by a psychologist?
No,
No?
no, it's just that they may leave this blank.
Who?
Okay.
The general physician?
The doctor.
The
Okay.
general physician, not the
Mhm.
psychologist.
Right.
Texas.
Because there's a bunch of wording up there that's hard to see.
Yeah,
You can see
but
it on
if
your
we get
paper.
it done by a psychologist, they will be able to
They
fill
should
this
be
out.
able to
Okay.
do it.
Right, because he says, like, I examine the proposed ward in accordance with the rules of Executive Commissioner of Health and Human Services Commission governing intellectual disability examination. So, a lot of your just general doctors, pediatricians, they're not going to be able to check that box because they're not doing the assessment there, that they're following it. So, and then you'll see down there too, a number 8, where they have to indicate whether they feel your loved one is totally incapacitated or partially incapacitated. Of course, if it's partially incapacitated, then you're probably talking a limited guardianship. Okay. Of course, total incapacity is then what we'll call a full or plenary guardianship. All right, and they also, you'll see number 9, their ability to attend a court hearing. And usually if it's a full guardianship, the court may not require the proposed ward to be present at the hearing. Now some of these things can be changing since we have new judges coming on the bench. Who's to say what's going to change here? I'm just basing it on what has happened up to now. And now usually if it's a contested guardianship or limited guardianship, then they might want the proposed ward there at the hearing. Now, I mean, they're welcome to be there. Usually though, the hearings take place during the day. And either 10 o'clock, around 9, 10 o'clock in the morning, and I think 1 or 2 of the courts, and then the other courts in the afternoon. Know that the guardianship hearings are always on, at least right now, they're always on Mondays. And my guess is they're probably going to stick with that. Because these judges hear other type of cases besides guardianship or probate.
So who, so if you weren't there or weren't able to be there, I almost think you should be there if you can be, but who would be meeting, who all would be meeting with the court when
Sure, well, that's a great question too. Now know that the potential guardian has to be there for the hearing.
I would think
Okay.
that'd be a good idea.
But as part of the process, the court's going to appoint an attorney ad litem
Okay.
to represent your son or daughter.
Okay, so you don't bring your own attorney, they appoint one for you.
Correct. The attorney ad litem is appointed by the court.
Oh, interesting. Okay.
Right, and let me go back to that process.
Is it like a district attorney or what are, I don't know how that works.
Sure. These are attorneys that actually have to have a certification in being an ad litem.
Okay.
You know, many of the attorneys out here in Fort Bend are kind of what I call solo practice attorneys,
Okay.
or they work for very, very small firms.
Okay.
So a lot of attorneys out here do a variety of, they practice different types of law.
Okay.
But like I said, in order for the court to appoint an attorney to take on the role of attorney ad litem, they have to have a current certification to be able to do that.
Okay.
And then, which means they've gone through some type of training,
Okay.
and usually as part of that training, they're learning about like the different types of incapacity, like IED. And so, they know that the proposed ward may be nonverbal, they may not be able to express themselves well, but they still, by law, have to come and meet with them. So let me go back to the flow chart here. So we're back at the point where you've met with the attorney, you've given them the doctor's letter, so they have now, your attorney is the one who actually will, they file the application with the county clerk's office. And one of the first things that happens is, there's several what I call due process in guardianship. And so one of those due process is that the proposed ward has to be notified that someone has applied to become my guardian. And that is done by a constable or sheriff actually serving the papers to the proposed ward in person. Okay? They don't have to sign for it, they don't have to read, but
there's a witness.
But the constable actually has to sign an affidavit that goes on record with the court that they have hand delivered it to them. Yeah. So if your loved one has a fear of people in uniforms, make sure you let your attorney know that, so that way they can request that someone in plain clothes come to see them.
It still could be an officer, but they could be dressed in plain.
Correct.
Okay.
Yeah, because we don't want to scare them. We don't want to
make them run, fight or flight. Okay.
Right. So this says a citation will personally be served to the proposed ward. It's going to have a bunch of legal jargon in it. It's going to say something about showing up to court after the 10th day, and so don't worry about that. Your attorney is going to communicate with you when you need to be in court. Okay. And they're going to check with you to find out when you're available for the hearing. It's just that there's certain language in the law that, and you'll see down here, there's a mandatory wait period. Once everybody has been notified, it has to be notified, there's a mandatory wait period before a hearing could happen, is all it's basically saying. So
I'm confused with one thing. So the first part says meet with an attorney. So that attorney that we are meeting for the first time, we're gonna pick someone, and then after that, the court will appoint a new attorney?
Okay, that's a good question. So there's actually 2 attorneys involved in a guardianship case. Okay. So the applicant attorney representing you is going to stay your attorney through the whole process.
Oh.
Okay. And then you're going to have the applicant attorney is part of that due process where the law requires that a proposed ward has to be represented by counsel. And so
the first attorney is guardian's attorney and the other one is ward's attorney.
Right. And I distinguish them by saying, the applicant attorney, because you're applying to the court, and then you have the attorney ad litem.
Okay,
thank you.
Because I know that you have to, like, if you're gonna be the guardian, okay, that makes a lot of sense, thank you.
Right, sure, yeah. Well, we jumped a little bit ahead on the attorney ad litem a while ago. But, So, like I said, the citations can be personally served the proposed award. Now, it also says notice will also be sent to biological parents and adult siblings. So, if you only have one, let's say only mom is applying to become guardian, and dad, of course, is still living and they still have parental rights, then dad has to be notified that mom has applied to become guardian.
Okay.
And they usually are required to sign a waiver. Meaning that, yes, I understand mom's applied and I'm in agreement with it. Also, if there's any siblings that are 18 or older, they have to be notified as well.
Okay. So in my case, it will be me and my husband applying, but my other daughter will be over the age of 18. So we will get like
So
3 notices?
Well, what will happen, now, if you and your husband are applying,
Okay, then,
neither one of you will be noticed. But
my daughter will
your
be.
daughter
Okay.
will be, and like I said, usually the attorney will have, and they can even maybe give it to you, it's a waiver that has to be signed in front of a notary. Okay. Like I said, then we talked about the mandatory wait period, and here, I've thrown this in because this is a new requirement, and your attorney is going to advise you when you will have to go and do this process.
I have never heard of this before. This is new. When did
It
they come
is
out
new.
with this?
This just went into effect June 1st of this year. Okay. And there's 3 things that have to be done online. There's an online guardianship training, there's a criminal history check, and there's a guardianship registration. And I was going to show that to you real quick. Okay, so this is the texascourts.gov website, and this responsibility has been placed under what's called the Texas Judicial Branch Certification Commission. And you'll see registration of guardianship is effective June 1st, 2018. This was legislation that was passed in 2017 that they had to get into effect. And so it was put into effect June 1st. And you'll see over there on the left, on this left-hand side, you see there's a guardianship training, which I've already pulled up as well, just to let you see what it looks like. And actually a lot of the information you're hearing from me is covered in this training. But you'll see they understand why guardianships may be necessary, overview of alternatives guardianship, types of guardianship. You'll see the different areas that have to be covered. There's like 7 little modules there you have to complete. Right now, this is only available in English. I'm hoping that as time goes on, they'll get this in other languages. And what's going to be important here is that when you complete this, you're going to be emailed a certificate. And so make sure that certificate you'll want to give to your attorney because they have to file it with the court to show that you completed your training. Right. And then you'll see too, let's see here. Well, this is registration. This is registering a guardianship, and you're going to create an account down here. When you go to click on like register a guardianship, and there's a little slideshow on there as well, and you have to choose on here if you're guardians, and then you're gonna, like I said, you're gonna create a login here. And what they're trying to do is they're trying to create a central database where all guardianships are registered. I believe the reasoning behind some of this is that way, if someone's picked up, let's say by the police, they're able to go to this database and find out who the guardian is for that individual. But like I said, your attorney will tell you when you need to do these steps, but we always like to make families aware that this is now a requirement that just went into effect, so. All right. Are there any questions about that? I know it's still kind of premature for most of you here, but.
So then you give a copy of your training certificate to your attorney, the one that is acting for the guardian, the person applying to become a guardian.
Correct. Yeah, the applicant attorney. So, and here's where I bring up that the court's gonna appoint the attorney ad litem for the proposed award, which we've already really kind of talked about that. But know that the attorney ad litem, they will come out and meet with your loved one. And they should do it at your home. So they'll probably give you a call, schedule a time for you to come out. And like I said, they'll visit with them, they'll visit with you. Kind of like what Eric says as he's telling this information. He goes, it's, you're gonna sit down, you're gonna tell your story, with the applicant attorney when you're first starting, and you're gonna tell your story probably another 3 or 4 times this whole process, okay? And so, because you're the person, you're the best person to tell the story. You're the parent. By the time you get to this process, you've been with them 18 years. You're probably the best advocate that the child has got. And so, so that's what it is. You're going to be telling your story, and like I said, they're going to come out and meet. The applicant attorney, your attorney, is going to then find out from you, okay, once everything's ready to go, they're going to find out from you, okay, when are you available to do, the hearing, and they're going to set that up with the court. I would say, it's hard to say right now the process, especially since we're getting new judges. We're going to have 6 courts too, so that should even speed up some things, hopefully, as time goes on. But probably once the application is filed with the court, you're probably looking at, I'm going to say 6 to 12 weeks to give you a time frame there is about how long this process will take, okay? Okay, so, now the other thing that I usually mention is that guardianship is what we call public record. And so that means a couple of things, and that is, you can actually, once the application is filed with the court, you can go to the Fort Bend County Clerk's website, go do a search on their database or records, and go to probate, and you can put in your name or the proposed ward's name, and you will see your case, okay? Now, they are very careful though not to make certain things visible, like the doctor's letter. Because it contains information about your child, it would be a violation of HIPAA. And so you can't, it will say that you don't have access to see that, okay? But it's just a nice thing to know that you can do this. And it's also important to know because, like right now, like I said, we have 5 county court law judges. We're now going to be getting a 6th one starting January 1. Well, I can tell you what they're going to start doing. They're going to start moving some of the guardianships around. And so, because it happens to us, it happened when they added the 5th one a couple of years ago. And so that means that the court over senior guardianship is going to change possibly. So, and the reason you need to know that is when you go to file your annual report, you need to know which court to file it with. So, okay, so now we're at the hearing, and at a guardianship hearing, there's a docket of cases, and so there could be 8 cases, there could be 12 cases, and I will tell you, usually when the judges are hearing guardianship cases, on that same day, they're also probating wills for someone that's passed away. And so that's usually the first thing they do. At least that's what they have been doing up to now. And I just say this because, if your court time is 1:30, you may get there 1:30 or a little bit before, but it could be 2:15, for the cases heard, depending on what's going on before you. And I say that as too, in case you're bringing your loved one with you, the proposed ward, because within the courtroom, it's you got to be very quiet, and there's a bailiff, and so just be aware of that.
Can I ask you a question?
Yeah.
So the citation, so that's just a summons for everybody to appear in court. Is that what it's for? The citation that's served?
Well, the citation served, I believe they're actually given a copy of the application, right, Charlie?
It should be.
An application of the guardianship. Now, there is going to be, like I said, there's going to be some jargon, legal jargon in that summons, saying, yeah, you need to appear. And that's why I'm
Okay.
saying don't panic about that,
Okay.
because, you know, your attorney will let you know when you need to be in court,
Okay,
okay?
okay, but it's, okay, so, and then they get a copy of the application, and that's the reasoning why we're appearing in court, and that's the information you're giving the ward and the people that are applying, and the attorney for the guardian. I don't know, I'm asking.
Right, no.
Does that have?
Yeah, because, you know, at the reason the hearing has to happen is because only a judge can legally declare someone incapacitated, okay? And so they have to hear all the evidence that's been presented. And so, of course, they've read the application, read the doctor's letter, but they also have to give the opportunity for the applicant attorney to present their case, so to speak, before the judge, as well as the attorney ad litem. And so that way, you know, that way the judge is hearing everything, and, you know, they will probably ask, you know, usually the applicant attorney, as they're presenting the case, they will ask questions of you. And they will prepare you for this ahead of time. Like I said, once again, it's going to be more like telling your story about your situation. Okay.
About the upcoming adult child.
Well, right, and helping the judge maybe understand, you know why they need a guardian.
Right.
Okay.
Okay.
You know, that's you know, the courts are very supportive of guardians. They want to be supportive of guardians. You know, so you know, they're your friend. They're your out. You know, they want to work with you. But they have a responsibility before they declare someone incapacitated that they're doing the right thing as well. Okay. Okay, so we're at the hearing. The judge determines the proposed ward is incapacitated. And of course, if it's no, then, which I've never seen that happen so far. But so if it's yes, the judge will sign a guardianship order that indicates amount of bond. So there's going to be the applicant attorney actually prepares an order that the judge has to sign, and really the order is what outlines what you know if you have full guardianship or not. Okay, if it's a limited guardianship, then it's going to be on there the rights that they've retained. Okay. But it's also going to indicate how much the bond is. And I know this sounds kind of strange, but Texas law requires that judges have guardians post a bond. You know, it makes sense when it's a guardian of the estate, because you're being given responsibility for what could be, you know, $100,000, $200,000 estate or more. So that makes sense. You have to post a bond for that. But just being guardian of the person, you still have to post a bond as well. And
What, it could be anywhere from $1 to whatever?
right now, it's been anywhere from about $10 to $100.
Okay,
I think the most that's ever been has been $100.
okay.
Now, like I said, we're getting new judges on the
Okay.
we're getting new judges on the bench. So
With the recent election, right?
pardon?
With the recent election.
With the recent election, yes. And then, you know, we also, you know, we had a judge pass away earlier this year, and we had a judge pass away last year. And then, like I said, we're adding the sixth court was just added as well. So that's why there were so many judges this particular election. So what you'll do at the end of the hearing, you'll be sent back to a room with your attorney and one of the county clerks or deputies, I think it's they called. And these are the things that you're gonna do. You have to file an oath. So you take an oath that you're gonna do your duty as a guardian, and then you will post your bond. It's because this is a cash bond that's being posted. Now, no, you only have to post it one time. Okay. And usually, like if you move from like one county to another, that bond transfers to that new county. Okay. Of course, the judge then will sign the bond order once he or she knows that you have posted the bond. Now this is usually done the same day, sometimes it could be a day or two afterwards. But know that the letters of guardianship, they cannot be issued until the guardian qualifies. So that means completing, all these steps here, all right? And know that your letters of guardianship expire 16 months from your qualification date. So your qualification date is a date you're going to really want to get to know well, almost like a birth date. And because that's going to be around that date every year is when you're going to want to file your annual report. But let me show you what a letter of guardianship looks like. Okay, so these are a kind of a gold yellow color, and it's hard to see in this. It's very faint. There's the county emblem is embossed in the paper, so that way people know it's an original. But you'll see it says, I, Laura Richard, clerk of the county court of Fort Bend County, do hereby certified on the 29th day of August 2016. BrazosBendGuardianship Services was duly appointed by said court, successor guardian of the person of Sean Michael McHenry, incapacitated, and that they qualified as such on the 29th day of August 2016. So our appointment date and qualification date are the same. And then it says this letter expires on the 29th day of December 2017. So that was exactly 16 months after that was issued. And so like I said, when you're ordering letters of guardianship, I usually encourage families to get at least 3 originals. That way because you always will want to have original with you. Then you'll want to give the school an original and the primary doctor an original. You can always go to the county clerk's office and order more if you need. They're only $2 each. Okay. Now let me go.
So the first one expires after 16 months, and then after that it's 12 months onward.
No, that letter for like us, for our agency, it's always going to be the same. It just rotates every year. So like this 29th day is December 17. Then it would turn to 18 the next year, and then 19.
Okay.
It's always exactly.
And how soon should we apply for a new letter or register?
Okay, that's good. Let me get you the annual report. Does everybody have the copy of the annual report in front of them? Okay. Okay. Now the annual report.
Which is one?
Yeah. Everybody, yeah, that's it. And so you'll see up there, your case is going to have a number. It's assigned a number as soon as it's filed, as soon as the application is filed with the court. Okay, so that's what that calls number is up there. And then you'll see guardianship of in the county court of law, and then it says this is going to cover for the period of blank through blank. So that. I'll use our example. It was August 29th, 2016. So, and this is in here to remind you, but like when we file the report, it's going to be like August 29th, 2016 through August 29th, 2017. And then every year, then 17 to 18, 18 to 19. Okay, does that make sense? Okay. So yeah, so when we file it next year, it's going to say August 29th, 2018 to August, actually I think I do 28, 2018. So you cannot file it till after that day of the month.
Oh.
So like if it's August 28th or 29th, you need to wait until after August, like August 30th would be the earliest you would want to file it. Okay?
So when you file it, and then you get the letter back to keep it with you.
Well, no, what's going to happen is you're going to file the annual report with the court, and then they're going to review it. The judge, you'll see, actually has to, on the last page there's an order there at the very bottom the judge actually has to sign that order saying they've approved the annual report. And what you're going to do when you file this, you're also going to request that they send you new letters of guardianship.
Right.
And so they'll send you new ones once it's been approved. And you'll pay for that. So every year you're looking at $10 to file the annual report, $2 for the judge's signature, and then $2 for each letter of guardianship you order.
No, I was just concerned about the time frame. Like, you cannot file it before it expires. So once it expires, you file it then, and then the letter gets to you.
Like if you go back to this one, like the one that we had up there, they, hang on. Let me go back. See this one up here? See, it expires December 29th. But we're gonna file this by the end of September every year. Because you have to give, the reason they give you the 16 months is because the court has to have time to review
Oh, okay.
and approve it,
Okay,
and
that's why it's
issue you a
16.
new one while
Okay.
your current one is still valid. Okay? All right. Wow, it's reaching out for money. See,
Time flies.
time does fly. All right. So yeah, this is all you should have to do every year is file this annual report. And the annual report, they're just wanting to know how they're doing. You report like when they've been to the doctor, you check to make sure what address they're still at. They're also just checking to make sure, do they still need guardianship? If they are, does anything maybe need to be modified? It may be that when they came in their guardianship, it was a full guardianship, but as time's gone on, they've been able to learn certain things, and now maybe they can make some decisions for themselves. If you can get a doctor to support that, then you can get the guardianship modified. And in some situations, depending on what their level of functioning is, they could reach a point that all their rights get restored again as well. And we've actually had 2 clients come through our program that their rights have been restored. Okay.
What's the normal mandatory wait period? Because after the citation notice, there's a mandatory wait period. How long is that usually?
Well, I think it's worded that it's like 10 days, and but rarely the hearing is ready to happen that quick. Okay. It's just that there's that mandatory wait period that once everybody's been notified before the hearing could happen. Okay, I'm running out of time. Or I've run out of time, I guess. Okay, the other thing I just wanted to talk about too is that our agency, we do offer a financial assistance program to help low-income families who need to obtain guardianship that may not be able to afford the full cost. And so be aware that if that is something you feel like you may need in the future, that is something we do offer. And we have an application process for that, and it has to be a guardianship of the person, non-contested case only, and has to be here in Fort Bend County. But there's no sense in going through all that right now, but just know that is out there, and know that we are here for you as a resource for this topic, because we know there's a lot to it. So if you don't have any other questions I can answer for you.
It's been great questions along the way, so
Yeah.
really good information.
Oh, well, good. Well, I'll be glad to come back anytime, and like I said, if everyone should have gotten my card, so feel free to email me or call me if you have any questions, all right? But appreciate your time today.
Thank you,
Thank
Kurt.
you.